Criminal law versus civil law cases, what's the difference? Welcome to the Law Review. I'm Monty, your trusted guide through the fascinating and sometimes complicated world of law. Today we're tackling a question that confuses many people. What's the difference between criminal law and civil law? Whether you're in the United States, the United Kingdom, or anywhere else, these two branches of law form the foundation of modern legal systems. But what sets them apart? How did they come to exist? And why are some cases resolved with jail time while others end in a financial settlement? By the end of this episode, you will have a clear understanding of 1. The history of criminal and civil law, 2. How these two systems function in the US and the UK, and 3. Their similarities, differences, and why they matter. This is a must-know topic for anyone interested in law, justice, or even the news. So let's dive in and explore this topic. To truly understand how criminal and civil law differ today, we need to start with their origins. The origins of criminal law. Criminal law has existed in some form for thousands of years. Early societies needed rules to protect individuals and maintain order. These rules evolved into laws that outlined what was considered a crime and what punishments should follow. Take the Code of Hammurabi, one of the oldest written legal codes from ancient Mesopotamia. It didn't just forbid crimes like theft or assault, it also laid out specific punishments for these offenses, often based on the principle of an eye for an eye. Later, the Romans took criminal law to the next level. They viewed crimes as offenses against the state, not just against individual victims. This concept shifted the responsibility of seeking justice from individuals to the government, a principle that remains central to criminal law today. The origins of civil law. Civil law, on the other hand, developed to address disputes between individuals or groups. Its focus was not on punishment, but on resolution, whether through compensation agreements or other remedies. The Roman Corpus Juris Civilis, or the Justinian Code, was a groundbreaking document in civil law. It provided detailed guidelines for resolving issues like property disputes, breaches of contract, and family conflicts. These ancient legal systems laid the groundwork for the criminal and civil law systems we use today. While they've evolved to meet modern needs, their fundamental purposes remain the same. Criminal law protects society, while civil law resolves private disputes. Let's start with criminal law. This branch of law deals with actions that harm society as a whole. Even though a crime might target an individual, like theft or assault, it's considered an offense against the public because it threatens the safety and order of the community. In the United States, criminal offenses are divided into 2 main categories. 1, felonies. These are serious crimes like murder, armed robbery, and drug trafficking. They carry severe penalties, including long prison sentences, and in some states, the death penalty. 2, misdemeanors. These are less serious crimes, such as shoplifting or public intoxication. Punishments for misdemeanors typically include fines, probation, or short jail terms. In the United Kingdom, the UK uses a similar structure but different terminology. 1, indictable offences. These are serious crimes like homicide or large-scale fraud. They are tried in Crown Court, often with a jury. 2, summary offences. These are minor crimes such as traffic violations or minor assaults handled by magistrates without a jury, the role of the state. In both countries, criminal cases are prosecuted by the government. In the US, prosecutors represent the state or federal government. In the UK, this role is carried out by the Crown Prosecution Service, or CPS. The burden of proof in criminal cases is very high. The prosecution must prove the defendant's guilt beyond a reasonable doubt. This high standard exists because the consequences of a guilty verdict, like imprisonment, are so serious. Now let's shift to civil law. This branch of law deals with private disputes between individuals, organizations, or entities. Civil cases do not involve crimes against society, but rather disagreements that require legal resolution. Common types of civil cases: contract disputes, for example, if one party fails to deliver a service or product as promised. Property disputes, such as disagreements over land boundaries or rental agreements. Torts. These involve personal injuries or negligence like car accidents or medical malpractice. Family law, cases such as divorce, child custody, or inheritance disputes. Burden of proof. In civil law, the burden of proof is lower than in criminal law. In the United States, it's called preponderance of the evidence, meaning the plaintiff must show that their claim is more likely true than not. In the United Kingdom, it's referred to as balance of probabilities, which follows the same principle. Outcomes in civil cases. Unlike criminal cases, civil cases do not result in prison sentences. Instead, the court may order the losing party to pay monetary damages, comply with an agreement, or cease a specific action through an injunction. Now that we've covered the basics, let's compare how criminal and civil law function in the United States and the United Kingdom. Criminal law in the United States, defendants in criminal cases have a constitutional right to a trial by jury for most crimes. In the United Kingdom, jury trials are reserved for serious offences. Minor crimes are typically decided by magistrates who act as both judge and jury. Sentencing also differs. In the United States, mandatory minimum sentences can lead to lengthy prison terms, even for non-violent crimes. In the United Kingdom, the emphasis is more on rehabilitation alongside punishment. For example, community service and suspended sentences are more commonly used. Civil law, civil procedures are generally more streamlined in the United Kingdom. Courts encourage mediation and settlements before cases go to trial. This makes civil litigation in the United Kingdom faster and less costly than in the United States, where pre-trial discovery processes can be lengthy and expensive. Let's bring these concepts to life with some real-world examples. Criminal law example. Imagine someone commits burglary. In the United States, the state prosecutes the case, and if the person is found guilty, they might face years in prison. In the United Kingdom, the CPS handles the case, and the sentence could include prison time or rehabilitation programs. Civil law example. Now, let's say two neighbors argue over a tree that crosses property lines. This is a civil matter. In both the United States and the United Kingdom, the case would likely end with a court-ordered resolution, perhaps the tree being trimmed or monetary compensation for damages. So, what have we learned? 1. Criminal law addresses offences against society with penalties like fines, imprisonment, or rehabilitation. 2. Civil law resolves private disputes, focusing on compensation or enforcement of agreements. 3. Both the United States and the United Kingdom share foundational principles, but differ in processes, court structures, and sentencing approaches. Why does this matter? Because understanding these distinctions can help you navigate legal issues effectively, whether you're seeking justice or resolving a dispute. Thanks for joining me on the Law Review. If you found this breakdown helpful, please be sure to like, subscribe, and hit the notification bell so you never miss an update. Have a topic you'd like us to cover? Drop it in the comments below. Until next time, I'm Monty, reminding you that knowledge is power, especially when it comes to the law. Take care and stay well.